Thank you. Court is resumed. Please be seated.
Justice Hennessy, I wanted to start back where we left off and provide a more complete answer to the question that you asked me.
The reporter needs a bit more time. We'll take a 5-minute break.
Court is stood down for 5 minutes. This court is resumed. Please be seated.
Justice Hennessy, I want to start where we left off before the break and complete the answer to the question you had asked about the apparent discrepancy in my submissions as to whether or not Canada is suggesting that a monetary award is appropriate for the breach of the duty to engage in a process to determine NCRR. And remember that my submissions are that there is no additional monetary award required to remedy this particular breach, which I submit can be remedied by a declaration. But there is an element of monetary compensation that is part of the compounding of interest on the ultimate monetary award for the first breach, the mandatory obligation to increase. That award is going to include compounding of interest we've seen. And the compounding addresses the time value of money. And what we're suggesting is the breach of the duty to engage in the process potentially, I think it's fair to assume, caused delay in the First Nations realizing their increased annuities, and that delay is already being compensated for as part of the monetary award for that breach. And what I'm suggesting is that Canada share in that monetary award. And as I indicated to the court, I'm not suggesting that Canada pay 15 to 20% on top of Ontario's award. I'm saying Canada should pay a component part of the overall award. And responsibility is, one part of Canada's responsibility will address the time value of money, which addresses the delay.
You say Canada's share in that monetary award, should it be some percentage, 15 or 20%, you say, represents the losses arising from the breach of the promise to pay and the delay and bringing that forward.
That's right. And that delay really is, I think, the implication of that failure to engage in a process, among other potential losses that can be addressed by a declaration.
Thank you.
Having in mind as well that when we're talking about a duty to engage in a process, back to my submissions that I made about it really having to be a flexible process, that the circumstances of diligent implementation, required elements of it may change somewhat over time. So there needs to be flexibility, which is why in my submission a declaration is an appropriate remedy. I want to turn now to an overview of Canada's positions on what I'm suggesting are the key issues. So the issues before this court are how to compensate for the breaches, the breach of the duty of diligent implementation, and then how should that compensation be paid, both to whom, which we'll get to with distribution, and by whom, which is the issue of Crown allocation. So how does the court compensate for the breach? This is broken down into, first of all, the legal principles that should apply to determine the nature of compensation for a breach of duty flowing from the honor of the Crown. And then with these principles in mind, what is the appropriate measure? Net Crown resource revenues or economic rents? What is the appropriate method to assess the present value? And what is the appropriate share? So on principles of compensation, my colleague Ms. Crew, as I said, will address this when we get back to it. But in overview, to summarize the positions that we set out in our written submissions, there's a few key points I'd like to make so that you can anticipate our argument, and it might help put other things in context. Remedies can be more than declaratory for a breach of the duty flowing from the honor of the Crown. Here, however, the breach is of a monetary promise to increase annuities. So our submission is that a monetary remedy is appropriate in this circumstance. It may not always be required for a breach of the duty of diligent implementation. The duty of diligent implementation is sui generis. Therefore, we say the breach of the duty is a sui generis breach, and the remedy should be sui generis as well. You asked my friend, is there case law on this? Is this a statement from the case law? And it is not. There is no case law on this, but I think it's fair to say that the White Sand Red Rock plaintiffs in Canada seem to be in essential agreement on this point, that the kind of remedy required for a breach of the duty of diligent treaty implementation is a sui generis remedy.
By sui generis, what do you mean?
Something unique. It means something unique, and I'm going to get to what exactly I mean by that. It is neither strictly common law damages, nor is it strictly equitable compensation, because it's not the same kind of situation as a breach of fiduciary duty. Having in mind the breach of fiduciary duty, the fiduciary relationship requires the fiduciary to act in the best interests of the beneficiary. Remember that the honor of the Crown, the Crown is assumed to act honorably in all of its dealings, and the duty of diligent implementation that flows from the honor of the Crown can be imperfect. The Crown is to seek and endeavor to do its best. It needs to be flexible. These are just some of the reasons why a strict adherence to principles of equitable compensation that we see in the fiduciary duty context should not be wholly imported into the breach of the breach of the duty of diligent implementation. But the remedy might contain elements of each, of both common law damages and of equitable compensation. Fundamentally, the remedy must flow from the treaty promise itself, from the treaty and from the honor of the crown. And here, flowing from the treaty means it should be monetary, because the breach, the treaty promise was a monetary promise. That's an example of how this sui generis remedy will flow from the treaty. There may be other situations of breaches of duties owed to Indigenous people that are not necessarily remedied by a monetary remedy, because the treaty promise may not be a monetary promise. But in this case, it is a monetary promise, and so a monetary remedy is appropriate. And when I say flowing from the honor of the crown, that the remedy must flow from the honor of the crown, what I mean is that it must be reconciliatory. And reconciliatory means restoring friendship and harmony and fair to both parties. So it needs to be reconciliatory of the relationship between the Crown and First Nations. It needs to be fair to both parties. And it needs to be sufficient to reflect honorable dealing on the part of the Crown. So as I mentioned, and my friends pointed it out, not all of the elements that we typically see in equitable compensation should be imported into this sui generis remedy. And for example, in our submissions, the principle of most favorable use and the principle of deterrence we submit are not required in a non-fiduciary situation as we have here. Now, although these are important points for understanding the principles of compensation for the breach of the duty of diligent implementation, on the facts of this case, they're actually not determinative. This issue about don't use most favorable use and don't worry about deterrence, I'm not saying they're actually, I think we differ with our friends on the applicability of the principles, but I don't think it really makes a difference to the award in this case, because
you don't think the difference of opinion will affect the proper remedy or the
yeah, and I'll give you two examples. Most favorable use. Well, what kind of favorable use are we talking about here? I think at most it might affect the rate that you use for bringing historic values to present value. Potentially, you could argue that 60-40 is the most favorable use, but there are all kinds of other arguments as to why 60-40 is inappropriate. It's unrealistic. So, and then similarly, this issue of deterrence. In my submission, that deterrence is typically required in equitable compensation fiduciary duty situations to deter future bad conduct, either of the same wrongdoer or another wrongdoer. And that's usually because in the classic fiduciary relationship, where you have, for example, a trustee who misapplies their client's funds and is never seen again, the remedy needs to be deterrent, because a declaration is not going to, a declaration that a person must do a better job next time is not going to have any effect. But here we have an ongoing relationship. And so a declaration will have an ongoing effect. This relationship is continuing in perpetuity. And furthermore, the award itself is deterrent. The question is not whether the award, the issue of deterrence is not that the award has the goal of deterrence, but rather whether it has that effect. And clearly here, an award of billions of dollars is going to have a deterrent effect. My friend admitted as much.
And I asked that question, and the plaintiffs were clear that the deterrent effect that they were looking for, they wanted to be addressed in orders with respect to future implementation, not in more money.
And of course, we'll get to orders for future implementation, but those as well, if there were and to be any such orders, would be declaratory. So overall, the award is to be an assessment of compensation that is fair, just, and proportionate in all the circumstances. And of course, we agree that it's not a mathematical calculation. It will necessarily, in this case, be imprecise. Nevertheless, the award must reflect actual loss caused by the breach. It needs to be based on a realistic assessment and result in realistic outcomes. And my colleague, Ms. Crew, will take you through the case law that emphasizes these points. Then I'm going to take you through the appropriate measure, whether it's net Crown resource revenues or economic rents. And as you know, our position is that the appropriate measure for assessing compensation is net Crown resource revenues. And I have two branches to this argument.
I go back a point, please. Must result in realistic outcomes. What does that mean to you?
Again, the best answer is probably to take you to the case law on this, which I'm deferring to my colleague, Ms. Cruz, so she can actually tell you what the cases say about realistic outcomes. But I think part of the answer is that it's necessary, it's part of a component that the loss has to actually flow from the breach. It has to address the breach and the actual loss. That would be realistic.
Well, if the actual breach is not paying money and the remedy is an order of payment of money, does that satisfy a realistic outcome?
No, I think that realistic gets into what is the amount then that you award? What is the amount of money? Well, that amount of money has to flow from the loss. It has to compensate, or at least attempt to compensate, the actual monetary loss. And you need to look at the actual monetary loss from a realistic point of view. Realistically, where would this money have been invested, for example? You know, realistically, is there a loss caused by this alleged failure to capture additional resource rents, or this alleged failure to engage with the First Nations to determine how resources should be exploited? These are the kinds of things that we would say the monetary award should not address. That's not realistic because it doesn't actually flow from the loss here. So in addressing why net Crown resource revenues are the measure as opposed to economic rents, there are two branches to my argument. The first is the easy one, the top layer, which we addressed with you, Justice Hennessy, in our opening statement, and you saw it in the expert reports of the Crown, of the experts retained by the Crown. These are things like, what does the judgment actually say? What does the decision of the Ontario Court of Appeal actually say? And here we get into the wording of the judgment and the Court of Appeal, and in fact, the stage 1 decision focused on net Crown resource revenues. In fact, the parties had agreed, and I'll take you to the judgment when we do that part of the argument, that it was net Crown resource revenues. And now, I know one of your questions may be, well, maybe that's because the judges at the time didn't realize, or maybe even the plaintiffs at the time.
One judge in particular I know.
Didn't realize there might have been an alternative.
Or the import of certain words and terms.
Yes, and I understand that. You know, I will be addressing that, having in mind as well, as I said, it wasn't just the court, but it was the parties who agreed on this approach. And the alternative was actually rejected by the Ontario Court of Appeal when they dealt with fiduciary duty and said, we're not talking about revenues that could have been captured by higher or different mining taxes, for example. I'll get into that in detail, but you know where I'm going with it. As I said, that's the first layer of argument. But I think the more fundamental argument is the second branch. And the second branch is this: economic rents is a conceptual way of understanding value, but it is unrealistic for assessing loss and compensation in this case, or in any case, it's never been done before. We're not aware of any case. We have seen no case law that has used this approach. When I say it's a conceptual way of understanding value, but it's unrealistic, that's because economic rents can't be measured. Now, of course, the assessment of compensation does not need to be perfect, and the estimate of economic rents, therefore, need not be perfect, but it needs to be comprehensible. And the theory of economic rents here is too hypothetical and too incomprehensible. And I'm going to take you through examples of that. So economic rents can't be measured, but even if they could be measured, even if we knew exactly what 100% of the economic rents would have been, economic rents can't be captured at 100% for a variety of procedural reasons having to do with, first of all, the fact that they can't be measured. But if they could be measured, problems of behavior, of tax avoidance, tax evasion, these kinds of things, the market economy that structures, that operates in such a way that it would be impossible to capture all economic rents. So that's what I will be addressing in my argument, probably on Monday. And in the context of dealing with net crown resource rents, of course, one issue of particular interest and importance to the federal crown is spectrum. Whether spectrum, now keep in mind, it doesn't matter whether we're talking about rents or revenues when we talk about spectrum, because the plaintiff's experts agreed that in the case of spectrum, they were the same thing. Rents and revenues were the same in the case of spectrum. If you need a reference for that, it's Exhibit 11, the Hutchings demonstratives at page 288. In any event, my colleague, Ms. McNamara, will be happy to address the Crown's argument on spectrum and why it's not the type of revenue that was captured by the treaty promise or the judgment. Then we'll move to the appropriate method to assess the present value. I don't mean to suggest that present value is simply a mathematical calculation. It's not necessarily always just applying an interest rate. It's an overall assessment, like all of the assessment of compensation of this sui generis type of award that I'm speaking of. But the experts have presented the present value in terms of using rates of return, as we know. And I'll be discussing and exploring those different rates of return. Essentially, you have two choices for an overall theory of present value. One is the plaintiff's theory of 60-40 investment in equities and bonds. And the other is a theory of present value based on an interest rate that is based, generally speaking, on government bonds. And here I'm going to lump together the long-term bond rate and the band trust account rate, because theoretically, they're both risk-free, conservative approaches. And they're not really that different than in their conception. And even really when you look at their average numbers over this time period, as we know, the long-term bond rate, an average of 5.01%, and the band trust rate was an average of 5.3%. So you think, well, they're roughly in the same ballpark. But of course, the interesting thing we know is that when you compound this over 173 years, even fractions of a percent can have multi-billion-dollar implications. And I'm going to come back to this point when I address my friend's argument that 1.44% rate of return for lost opportunity is insufficient. I'll come back to that argument.
Before you move, though, what is it that you want me to understand about this, the risk-free nature and therefore the preferable nature of long-term bond rate and the band trust account rate. I'm thinking of the evidence of Professor Stiglitz, who said over these long periods, a 60-40 portfolio approaches risk-free investing. If I have that right. So
Yep.
that was his evidence.
I understand that. I think the issue is, here we are going to be realistic about risk taking. And I think Professor Booth got into this issue. It's one thing to say, yeah, I'm going to buy a long-term bond, but realistically, people are afraid to hold a 30-year bond and they end up selling it early. And so this idea that, well, we'll be willing to wait 170 or who knows how many years, we're not going to balk, to get nervous. We're going to just hold on to this forever and ever. If you have that luxury, you might do that. Okay, for example, these long endowment funds, pension funds that we heard of. But realistically, these First Nations would not have been thinking on this kind of long-term horizon. They wouldn't have known that over the long term, equities were going to be potentially just as risk-free as bonds. Inexperienced investors are guided towards these kinds of safer investment vehicles partly because they don't have the same risk tolerance. And I know we have differences, there's differences in the evidence as to how risk tolerant the First Nations were. I'm going to suggest that the First Nations weren't risk tolerant. One of the points that you may recall that was made during Professor Stiglitz's cross-examination was, we weren't talking about sophisticated investors with access to markets. We were talking about individuals and families living in remote areas and people who needed to spend the money that they had. So it's not realistic in my submission to expect that these First Nations would have just parked their money to in investments with a very long-term and uncertain horizon. Really, the way to deal with risk is, if you're risk averse, as actually most of us, I think, are, investing in a bond, you're eventually going to get your money. It's more realistically, not just on a practical level, and we'll get into that, about why, as I said, these are relatively small bands in relatively remote areas, and what's the realistic likelihood that they would have engaged professional investors on their behalves to invest in 60-40. The other problem is, as we'll get to, realistically, they were likely going to be hemmed in to some degree by the Indian Act, realistically. And I also suggest realistically,
they were going to be what?
Hemmed in to some degree by the Indian Act. And I'll get to that. You asked some questions of my friend about that I'm looking forward to answering. In any event, remember that regardless of which choice you take, whether you agree that the First Nations would have invested in stocks and bonds and been prepared to withstand the risk of the market, not knowing where it was going to go, we can look with hindsight now and say, we've seen, as the expert said, over the long term, investing in equities is just as risk-free as investing in bonds. But in the short term, in the blips of history, when that's the issue of hindsight, right? With perfect hindsight, you may say, I could have left my money in equities, but in the moment, when you're dealing with variations in history and in returns and that, it's one thing, like Professor Booth said, it's one thing to say, I'm going to hold on to this. It's another thing to actually do it. And the example, of course, that Professor Booth gave was these bands would have lost 75% of their holdings during the Great Depression if they'd held on. And realistically, can we expect that these bands would have acted differently than pretty well everybody else? So I wanted to come back to the point that I made earlier, that whichever of these routes that you choose, you have to keep in mind, you're not going to be able to arrive at a precise amount for either, a precise amount of the present value. And that is because, as I said earlier, the experts did not provide calculations for every possible scenario of net Crown resource revenues or of rents. The experts calculated present value using unique interest rates in each year. They happened to average 7.2% for the 60/40 and 5.3% for the BTA. But in every year, it was a different interest rate applied to a different amount that could vary in every year, depending on the decisions that you make on NCRR or economic rents. So keep in mind to be wary of simplistic calculations. Now, of course, one of the things I'll be addressing is the Booth and Kersner approach. Canada readily admits that the Booth and Kersner approach has its limitations. Chief among them is that past spending is not necessarily indicative of spending in different circumstances. Canada acknowledges that. Professors Booth and Kersner acknowledge that. But Professors Booth and Kersner did not make up their approach. This isn't really their approach, and it was fair for Professor Booth to say so. It was an approach that they devised specifically in response to the Ontario Court of Appeal's decision in Whitefish. The Ontario Court of Appeal in Whitefish was uncomfortable with an assumption that in that case, the unpaid money, which in that case related to improvident sale of timber, the Court of Appeal was uncomfortable with the assumption that that money would have sat in the band trust account, accumulating compound interest for 120 years. And the Court of Appeal in Whitefish explicitly said, what we need is evidence of actual spending patterns, and said, what we need is someone to look at spending patterns in the historic trust accounts. Now, this was just guidance. My friends say it's obiter, but it is at least nevertheless guidance on this very issue from the Court of Appeal. So it was a reasonable approach for Professors Booth and Kersner to take. In fact, they took it upon instructions. How would you, they told us that in their evidence, that the Department of Justice asked them, look, here's this Whitefish decision. How would you interpret that? And this is how they came up with their model.
Well, that might have been the first and the second time they tried.
Well, those first and second times may be distinguished as well, Justice Hennessy, because I'll tell you, one of the primary concerns about the approach was, of course, it doesn't take into account the fact that spending patterns differ depending on how much money you have. But another important criticism in those cases that criticized their approach was that it was too complicated. But it's different when you're dealing with a case before the specific claims tribunal, where the statutory limit is $150 million. And where you're dealing with a case here where the plaintiffs are asking for some portion or all of $126 billion. And in my submission, it is appropriate in these circumstances to look at complex analyses. So I don't think that the criticisms made by the specific claims tribunal are persuasive here. And I know my friends will say, well, there's also Justice Zinn's decision in the federal court. Even in Southwind, the total award was $30 million. Of course, now it was sent back. But, and furthermore, that's the federal court where Justice Zinn wasn't at all beholden to the Ontario Court of Appeal. And I don't want to be, I started off these submissions by acknowledging, Justice Hennessy, the problems with the Booth and Kersner approach. So I'm not, all I want to say is let's not just throw the entire baby out with the bathwater here. There are elements of the approach that are worth considering. And one of those elements is the fact that it's grounded in the Ontario Court of Appeal's discomfort with the concept of simply bringing forward values at 100% compounding for all these years. It's grounded in this idea that we have to look at, realistically, how would the money have been spent? It wouldn't have just sat in a trust account or in some investment account in New York City. It would have been spent, and how would it have been spent? It addresses that. And another part of the Booth-Kersner approach that I think is worth this court's consideration is the way they deal with depreciation. It's very compelling, I suggest, to consider that some of the things on which the band would have spent the money, such as, items of human capital, have a natural depreciation rate. And of course, the example that was given was the money that you would spend on a new pair of glasses. Doesn't mean that the glasses, continue increasing in value at compound interest rates year over year over year. So depreciation is a factor that, in my submission, brings the analysis of present value into line with realism. And this is where I get back to the original statement that I made, where I said, we talk about bring forward as though it's simply apply this straightforward interest rate, but really what you're supposed to be doing, Justice Hennessy, is assessing present value. This is another distinction with the specific claims tribunal, where the statute actually requires them to use a calculation to bring forward amounts to present value. They talk about bringing forward, but I'm not suggesting that that's the method that you need to be following here when we're devising a sui generis remedy. Here, we're looking at an assessment of present value, and it doesn't need to be a straight mathematical application of an interest rate. It needs to be an overall assessment, which in my submission should take into account the realism that's injected by the Booth-Kersner approach. And this is why overall in our submissions, you'll see that we take the position that the figures for present value that you arrive at when you compare net Crown resource revenues brought forward at the government bond rate, when you look at those figures, they are a reasonable. They provide a reasonable parameter for the award in this case. I'm not saying therefore apply a specific interest rate for the present value analysis. What I'm saying is these figures that were calculated on the bond rate are reasonable when you have in mind that the bond rate of 5%, there are arguments as to why it would be appropriate, but even if it's not entirely appropriate, it represents a good compromise between if you take the realism of the band trust account rate, which is really, I'll make argument as to why that's pretty realistic, that that's what would have happened here.
I'll put this out here now, and it was something that occurred to me as I read your submissions. When you say in many different ways, it represents a good compromise, or it's a good, if you take off this extreme and that extreme and you arrive here. It sounds like a submission on negotiations.
Is that a problem, Justice Hennessy?
Well, this isn't, final interest negotiation. And you might tell me that assessment is like mediation, finding something that keeps both sides happy. But overall, I must apply the law to the facts, and that is my primary task.
Of course.
So I'll just leave it with you. And I can't shortcut this case, as you well know.
I understand. And thank you for explaining it to me that way, because I think my answer was too quick when you said, this is like mediation and why, and I said, is that a problem? I had really forgotten that part of mediation that you expressed as finding an answer that makes both parties happy. I hadn't thought about that part of mediation. What I thought about the part of mediation is making compromises, taking a principled approach, understanding your adversaries, or attempting to understand your adversary's position. So in that respect, I don't make apologies for Canada's effort to reach a compromise position. And it's not on the basis that everybody's got to live with something that they're not quite happy with. It's really on the basis that as part of reconciliation, we are to accept our responsibilities and make efforts to reach common ground. So I would submit that our compromise approach serves that purpose, deliberately serves that purpose of trying to make a compromise. And furthermore, it's appropriate in this case where precision is, of course, not required and of course not possible. And I would submit that the figures that we are proposing in our written submissions aren't just pulled out of thin air. They are, you can reach these figures on a principled understanding and analysis of the evidence. So that leads me to the appropriate share. And again, I readily admit Canada's numbers are soft. We are not there. I will be making submissions as to why 84% and 58%, as claimed by my friends, are inappropriate. They're not supported on the evidence. And I'll go through why. In the alternative, Canada proposes a range of between 20 and 50%. Now, 50% on the basis, as we set out in our written submissions, that all of the experts agreed that 50% is a reasonable approach based on bargaining theory. So there's the evidence for you on that. Now, 20%, I readily acknowledge, is difficult to see in the evidence. But the position that Canada takes is, and it was actually on the basis of Professor Mintz and Mr. O'Riordan's suggestion, that one way of looking at it is a population-based approach, because you look at the per capita results of the share, which has been done in other countries. I think they gave the example of the former Czechoslovakia. It's not a wild and crazy idea to look at the relative populations. Now, Professor Mintz and Mr. O'Riordan readily acknowledge that the 10% of the population we're seeing today is not reflective of the historic population. And we admitted in our own written submissions, it paid paragraph 257, I believe it was, that, yeah, the problem with the population approach, if you start with 10% population, is it doesn't reflect the historic difference in population. And I have that paragraph number in my mind because I know my friend, Mr. Gover, suggested that we hadn't accounted for that, but no, we admit it. On the other hand, there is no evidence before you as to what the relative populations were over the time frame. That's a shortcoming potentially of all of the parties. You don't have that evidence before you. Mr. O'Riordan made the assumption when asked on cross-examination, well, probably in 1850, the population of the Indigenous parties was closer to 100, but that was just supposition. There's no actual evidence of that.
Well, there's a fair amount of evidence in stage one about how few European settlers there were
in the early years.
So that's all we know.
No, and I'm not denying that, and neither did Mr. O'Riordan. But what I'm getting at is we don't have, unfortunately, we don't have the evidence before you about what the relevant populations were. We do acknowledge that that's a shortcoming with the population approach, right? But, you know, and we've suggested 10% isn't going to be fair. So you would have to augment, this is what Professor Mintz and Mr. O'Riordan suggested, you would have to augment this population-based start. And we're suggesting double it in order to take account of the fact that we're also trying to address differences in wealth and needs, and also acknowledging that the population wouldn't have always been 10%. But keep in mind that if you were to award the First Nations 20% or 50% of all of the net Crown resource-based revenues, this doesn't mean that the non-Indigenous population gets the other 80% or 50%. Instead, the Crown spends the other 80% or 50% on the Canadian population, and we all benefit, including the First Nations.
You're talking about going forward.
Yes.
Right, but
well, and in fact, I think
argument on share is first and foremost on past compensation. So when you say the government spends it on the rest, it's already spent.
Yes, but I think it's also fair to look at it from the past as well. If you think Well, the money's already been spent, and now the Crown has to, calculate what would have. But what I'm saying is that the benefits of these resource revenues have inured to everybody in some way, some people more directly than others, some people in better ways than others, but the benefits have inured to the population.
Well, that's what the evidence on income gap and wealth disparity challenges.
I think what it challenges is, yes, I think there's no doubt, and nobody disputes that there is a disparity in incomes, but I don't think the evidence states that all of the money that was collected by the Crown was spent to the exclusion of any benefit for the First Nations. And I don't want to take that too far because, as I said, I'm acknowledging here that 20 to 50% is what Canada says is a more realistic and reasonable share in the circumstances than 84% or 58%. The next major issue is distribution. We agree with Nami-Gusasegagan that an amount should be held back to permit consideration of their eligibility to a share in the award. Just as an amount will have to be held back until determination of the G7's contingent interests. We know NAME has contingent interest. That's why they were granted leave to intervene. Canada wishes to be respectful of their contingent interest and not prejudge their claim that they are treaty beneficiaries. And Canada also prefers to allow Indigenous peoples to resolve disputes between them among themselves. That would be the preferable outcome. And we will submit that these are matters that can be left to post-judgment motions, but that it would not be principled to effectively cut out NAME prematurely. On the issue of future implementation, you have our position in our written submissions that the stage 1 decision already provides all of the required orders to ensure treaty fulfillment. The stage 1 judgment in particular spells out the duties of the Crown. The decision itself provides additional guidance, and as will your decision on stage 3 compensation. It will provide guidance for the future, but it is not necessary for this court to make specific orders about future implementation, and it would be dangerous to do so, I would suggest, because we just don't know what the future holds.
What about, in anticipation of this argument, we don't know what the future holds. What about a one-time set of directions?
What do you mean by that?
Well, let's say everyone agrees we don't know what the future holds, but at least in the first year or 2 years or 5 years, you have to do this. And then in that engagement process, you might figure out what you want for the future. But is the court not faced with this conundrum of long standing ignoring of the obligations and being silent on what the Crown must do the day in the days after this decision, in that year after the decision, that whatever is reasonable, that 5 years, that they must hit 1 milepost. Is the court not, should the court not be worried that they have left the plaintiffs with the, I'll call it, horror of somehow hitting the wall and not having anything to fall back on, except further litigation?
Should the court not be worried? Yes, the court should not be worried. The court has made declarations. The parties have, the Crown, I submit, has shown its willingness to engage with the First Nations. And this gets into the question of my friend's complaint. Well, the Crown has done nothing so far. And I have 3 answers to that, Justice Hennessy, and now might be the time. One answer I've already noted, that Canada has met its obligation to share information about federal revenues on spectrum, even though it's still a live issue whether spectrum is a shareable revenue. We've provided that information up to date. But more fundamentally, Canada and Ontario both have been engaging in processes with the First Nations in the context of this litigation. As you know, the parties have met, the council have met, their experts have hot tubbed. And this, I think, goes toward some measure of comfort, I would think, for the court, that the parties are willing and capable of working together. But you have to keep in mind that the fact that we're in litigation is going to place limits on what we can accomplish. And right now, we are well over $100 billion apart. That's why we're in litigation. But that doesn't mean that, and we're going to get the guidance of this court to help set the path the way that it needs to be set. The fact that we're in litigation doesn't mean that we are not capable of working together in the future. We just need to get over this hump, and we'll get that with your guidance through this decision. I think it's very fair to say.
What you're saying is that a decision on remedy, it's like reading the jury, that the decision on remedy will tell you what you have to do in the future.
It certainly will.
Vis-a-vis money. But will it say anything about engagement?
Yes, and I'm not just talking about the amount of money. When I talk about your judgment will provide guidance, it's not just the amount of money, it's how you address rents or economic, which are appropriate expenses or appropriate areas of revenue, or what you have to say about share. So it's not just, it depends on how much money you award, Justice Hennessy. It's what do you say in your judgment? What do you tell the parties is fair from the point of view of what kinds of revenues need to be shared? What kinds of expenses are to be considered? These are going to provide guidance for us. So the final point I want to make on that is that there is no doubt we are living in a different world than we were even 20 years ago. Let's not lose sight of the fact, the efforts that people are putting together towards reconciliation on both sides. And I can tell you that when I tell my colleagues and friends who are non-lawyers about the case, and lawyers in particular, they're not interested in these fine, detailed arguments about equitable compensation versus sui generis rights. They're interested in, what is it like to go in a sweat lodge, Ms. Evans? What is it like to meet an elder? What is it like to throw tobacco on a sacred fire? These, I think, are examples that we're not living in the same world we were living in even 20 years ago. And I think these are measures of the true commitment of parties on all sides towards reconciliation, and that means diligent implementation of the treaty. So I do not think that it is appropriate to judge future participants in the reconciliation process by the way that participants behaved in the past. The last area that I want to address is Crown allocation. Our position is that each Crown is responsible to share the resource revenues that it collects. This is based on common sense. It's also based on Section 109 of the Constitution, which provides that Ontario took the lands and resources subject to the First Nations' interest in a share of the proceeds of the land ceded. A corollary of that is that Canada is also responsible to share any proceeds it collects, which Canada accepts. And so I said it's based on common sense. It's based on Section 109 of the Constitution. It's also based on the common law, we've variously called it the common law of state succession or Commonwealth common law, the general idea that liabilities follow the assets. All of these arguments and all of the relevant legal and evidentiary arguments were already considered by the arbitrators and the Supreme Court of Canada over 100 years ago. You need only follow the arbitrator's decision, supported by the minority in the Supreme Court of Canada, whose understanding of the treaty promise is consistent with the stage one interpretation. We heard a lot from the witnesses about the history, which was very interesting. It was a long and winding road, but it's not a path you need to retread, because you can simply look at the way the arbitrators and the minority in the Supreme Court dealt with all of these issues, because they are your best source for consideration of these issues. They've already been addressed more than 100 years ago by the arbitrators and the Supreme Court. The difference is now we're operating under an understanding of the treaty that is entirely consistent with the way the arbitrators understood it and the way Justices Gwynne and King understood it. And interestingly, you might recall that the Supreme Court decision was a 3-2 split. And in the majority, which found that the liability was joint of Ontario and Quebec, Justice Sedgwick said, and I'll take you to it later, said, now if this promise was that the First Nations were to receive an interest in the proceeds of the land, well, then it would be Ontario's burden. And I'm going to show you where he says that and suggest to you that now that we understand the treaty the way we do, he would have been in the majority. Like he would have joined the Justices Gwynne and King, and we would have had a 3-2 split. So I'm going to take you, when I go through Crown allocation, I'm going to take you through that decision in quite a lot of detail, because interestingly, all of the arguments you're hearing today from my friends from Ontario in particular have already been addressed. And this is going to be a good guide for you as to how you should see the issues as well. The final point that I will be addressing in Crown allocation is, of course, the release that Ontario suggests that Canada released Ontario and Quebec from any further liability. But of course, that release only applies if you follow the section 111, 112 route, which I'll have to refresh your memory about that, I'm sure. And it also restricts recoupment by the Dominion from Ontario and Quebec. It doesn't restrict at all Ontario's direct liability to the First Nations. And of course, the First Nations weren't party to these inter-provincial agreements or intergovernmental agreements. So I'm done my overview, and I'd like to dive right into Crown allocation. I think it's a natural time for a break in my submissions if it's not too early for the court.
I'll just catch up and then we'll take a break. Thank you. Just one moment, please. Thank you. We'll take a break. 15.
This court is stood down for 15 minutes.
All right.
This court is resumed. Please be seated.
Justice Hennessy, for the Crown allocation argument, we have put together a short compendium that I understand has been shared with my friends electronically, and we have a few paper copies that we have distributed as well to those who want paper copies. It's a fairly thin spiral bound volume.
Thank you very much.
And I'm going to be spending a lot of time, as I said, on that Supreme Court decision from 1895. It is included in the compendium, but I went through it electronically and did a lot of highlighting, which I think is going to help sort of short circuit the submissions. So I understand my colleague has also circulated the highlighted version, and that's the version we'll be putting up on the screen.
Very nice.
So in terms of crown allocation, as I noted in my overview, there's a lot of history, letters, transcripts, arbitration awards, court decisions, and you heard a lot of evidence from 3 different experts on all of it. All of that is very interesting and helpful for context, but of course, those letters, transcripts, even the arbitration awards are not determinative of the issues now before you, most obviously because they did not include the First Nations. And for the most part, they were premised on a very different understanding of the treaty. When you look through those historical records, you see how much of a reference there was to $4 as though it was a cap. But nevertheless, as I noted in my overview, there is certainly something to be gleaned from and learned from in the arbitrators and Supreme Court decisions. I will refrain from a detailed review of the history in these submissions. It's set out in chronological order in our written submissions. So if you have, forget the order of things, that I wouldn't be the least bit surprised if you do. It's very complicated. You can follow the chronology in our written submissions. So the topics I will follow are these. First, I'm going to address that joint and several liability doesn't apply here, and Canada is not the paymaster. Then I'm going to address that allocation is covered by Section 109 of the Constitution. Then I'm going to address the common law of state succession, which is really only relevant in 2 respects. One, it really bolsters the Section 109 approach, because they're really both based on the idea that you take the assets subject to the corresponding liabilities. It's also only relevant to respond to the plaintiff's argument that the Constitution doesn't apply because it postdated the treaty. So if you were to find that the Constitution doesn't apply, and I certainly don't invite you to do that, we do have the common law to back us up. So then the fourth topic being why we're not joint and several liability, why it's Section 109, why common law bolsters that. The fourth issue is then the historical background. And as I said, most of that is covered in our written submissions, and what I will be taking you to really comes down to the decision of the Dominion Provincial Statutory Arbitrators and in 1895, and the Supreme Court of Canada and Judicial Committee of the Privy Council, I'll call them the JCPC. We'll get into their decisions. And then, of course, post the JCPC decision, we got into the capitalization and the so-called release, so I'll be addressing that. But to start with, why we're not in a situation of joint and several liability. Joint and several liability is a concept that is used in private law, tort, and contract cases. And the White Sand Red Rock plaintiffs give us an example in their written submissions and in the oral submissions of Justice Duncan's recitation of the classic example, which is really a contractual example of B and C jointly promising $100 to A. This is a contractual situation where joint and several liability is obvious because it's contracted for. The other kind of situation we see in the law is in the tort.
In what case do we see Justice Duncan?
It was referred to by my friends, and I'll have to pull up their, it wasn't an Indigenous case, and I know if I could pull up my friends. It's in the compendium of the red rock, white sand, and I think
you
I've got it
can-
right here. No, I think I've got it. It is the, was it not in your compendium? Anyway, it's in your written submissions. It's in your written submissions. I have tried to embrace electronic technology and get away from using paper, but I'm telling you, I really miss my boxes and boxes of paper.
So it's
Briefs.
page 140.
Generational.
Chieftain Energy Limited versus Gold Resources, Inc., 2019. Paragraph 604 of my submission.
Thank you.
You're welcome.
I missed the plaintiff's name.
Plaintiff's name is Chieftain Energy Limited.
I can say it with the microphone, yeah. It's, as my friend said, paragraph 604 of his submissions. The case is Chieftain Energy Limited Partnership
Thank you.
versus Gold Resources, and it's a 2019 case. I can give you the site as well if you'd like it. It's here. Would you like the site?
I just like to know the court.
Okay. It was the Yukon Supreme Court. It was
Right.
Justice Suzanne Duncan. In any event, the example given was really a contract situation, whereas I said joint and several liability is obvious because it's contracted for. I'm not saying in the facts of that case, but the example that she gives when the judge, when the court explains the different types of liability, the example Justice Duncan gives is a contract case. But joint and several liability is also seen in the tort or negligence context. It's seen in personal injury cases such as motor vehicle accidents, where more than one tortfeasor is involved, 2 cars hitting a third, for example. And in that negligence context, the Negligence Act requires the court to apportion liability, and each tortfeasor has a statutory right to seek contribution and indemnity from the other. That's a statutory right. But there is no authority for joint and several liability in the public law context that I have found, and my friends did not refer to any cases in support either. It seems that the plaintiff's argument in favor of joint and several liability is only based on their contention that the First Nations shouldn't have to concern themselves with which crown to pursue. The best authority that we can find, I've included in our written submissions, it's Good versus Toronto Police. It's included in our submissions, and I think it's also included in the compendium. Paragraph 142, which I readily acknowledge, Justice Hennessy, is a weak authority. This is a case where claimants whose charter rights were allegedly infringed in crowd control argued that a number of police agencies should be jointly and severably liable, or that one or more of them should be vicariously liable for the others for these charter breaches. And the court held in that context that joint and several liability is a private law tort concept. In fact, what they say is, in effect, the plaintiff seeks to import the private law concept of joint and several liability into the charter violation claims. This is wrong in law and must be struck. As I say,
Tell me which court this is.
this is the Ontario Superior Court, and this particular decision was then appealed to the Court of Appeal, and I believe leave was refused by the Supreme Court on different issues, though neither the Court of Appeal nor the Supreme Court addressed this particular issue. And this is what I mean when I say it's not authority you can hang your hat on. It's the best we can find. It's when I say you can't hang your hat on it, what I mean is I readily acknowledge it doesn't directly address our situation here because they're talking about charter damages. But I think the main point is that in both our case and in Good, it's a public law context, and the court seems to be accepting that joint and several liability is a private law concept. Part of that, the thing to keep in mind is that the right of contribution and indemnity is also uncertain in the public law context. I mentioned before that it's made a statutory right under the Negligence Act, but it's far from clear that in the context of this case, if and how contribution and indemnity would work. We know that Canada has a claim for contribution and indemnity from Ontario pursuant to section 112 of the Constitution. But that's only in the alternative if you were to go down that road, the 111, 112 road. And Ontario has no right of contribution or indemnity against Canada. They pleaded one, but it was struck for failure to disclose a cause of action. And I referred to that in the written submissions as well. It's also in the compendium. It's a 2005 decision of Justice Smith. So a finding of joint and several liability in this case would be a novel finding, being in the public law context without any authority cited by the plaintiffs. And I submit then you are best to avoid weighing in on that. You don't need to. A finding of joint and several liability would do no good anyway, because it wouldn't resolve the issue between the crowns. The issue could potentially end up back in court. You have the parties and the evidence before you now, and you can make a determination on the allocation of liability for this augmentation promise as between Canada and Ontario. With respect to Paymaster is even less present in the case law. There's no case law for an assertion that Canada should be the paymaster here. It's really just another way of saying joint and several liability. Let us collect from Canada and let Canada go and collect from Ontario. So it's really the same as joint and several liability. And for the same reasons, I suggest you shouldn't make that decision. It would be an unusual and novel award. It would raise complications for rights of contribution and indemnity. But primarily, it's just not necessary when you have the parties and the evidence before you and can make a determination on the issue.
How do you get to an award of 15 or 20% if it's not joint?
Well, as I stated in my outline, this is intended as an expression of Canada's accepting responsibility. And I can't really go any further than that, Justice Hennessy. I'll readily admit it's based on a sense of an effort to take responsibility. It's not based on a legal precedent. It's not based on a mathematical calculation.
But as I said, my job is to apply the law to the facts. And what law, if any, are you saying would help me make an award of 15 to 20% liability against Canada?
Yeah, I understand your question. It's obviously a very good one. The 15 to 20%, remember, we're not actually claiming that Canada is liable for 15 to 20% of the under the Constitution. Because when I go through this Constitution with you, the Constitution and the implications of it with you, the liability rests with the Crown that collects the revenues. And we're certainly not saying that Canada collects 15 to 20% of the revenues. But we are acknowledging that there's got to be some implications to the fact that Canada did not engage with the First Nations to discuss resource revenues. And like I said, might have been able to bring Ontario to the table at the very least. And so we acknowledge that it's reasonable that Canada should bear some responsibility for that. And the figure of 15 to 20% it reflects less than 50%. We certainly don't believe, and I made these submissions in the opening, Canada is the junior partner here. So what does junior partner mean? In our submission, a maximum of 20%. It's really based on an effort to take responsibility and arrive at what we submit is a fair result. And I do take your point that, of course, you have to be able to ground this in evidence and fact. But recall as well, one of the cases that I took you to in opening was the Guerin case, where following on other cases as well, the judge in that case noted the impossibility of arriving at a precise amount. And then at some stage, the judge is just required to do the best that you can do. And I think it sort of follows with this sui generis approach to the award of compensation here. I would, if I were to take, quite frankly, Justice Hennessy, a purely law-based approach, I could just as easily tell Your Honor, tell the court that Canada bears no liability whatsoever. It's all Ontario's. But that's not a position my client wants to take. I should also note that, of course, and I made it clear in the written submissions, the 15 to 20% that we are proposing in the written submissions is only with respect to liability for the past, because it's premised on this understanding that Canada breached this duty to engage with the First Nations to determine net Crown resource revenues. But of course, the intention is, now that we have this declaration and we know the rights and responsibilities, that Canada will engage, and it will not be necessary for Canada to take on any responsibility for sharing revenues that it does not collect. That's why we make the point in our written submissions that whatever you decide with respect to Crown allocation for past compensation you should not be setting a percentage, for example, for the future. And I know my submissions may have been a little bit confusing on that point, because at points I have said, you know, don't make orders about the future. And I've said, don't make an order about how responsibility should be allocated between the crowns, you know, for the future. But I do, on the other hand, understand that, of course, the First Nations need to know who do they turn to. And I am telling you that the Constitution tells you who to turn to. You turn to the Crown that actually collects the revenue. So here's an example where your decision, if you were to adopt my submissions, that the Constitution tells us the Crown that collects the revenue is responsible to share it. If you adopt those submissions and make that determination, that will guide the future, without the need for you to make a explicit order that from here on in, Canada's liable for X percent.
So your position is that, or the pathway to the decision that you seek is a finding of X amount as an assessed amount of compensation for the breaches of breach of treaty and breach of duty to engage. But the court find a single amount of that.
Yes.
Say that of that amount, and do all the work that is required to ground that in evidence.
Yes.
And then you say, and of that, take that and allocate 15 to 20% to Canada.
That's correct. And it's really
And
not.
they're not jointly and severally liable.
That's correct. And it's
Just assess Canada as at fault for that portion.
yes, and it's really not that unlike a tort situation where you have to apportion liability. The liability doesn't have to be joint and several for the court to apportion liability between parties. It's not, you don't have to find joint and several liability before you can make an apportionment of liability.
No, but you're asking for a single assessment.
That's correct.
Damages.
That's right. And that's because, as I noted before, the breach is the breach of the duty to augment the annuities when resource revenues permitted. That's one breach that attracts a monetary award. There's one monetary award. That monetary award includes a component of compound interest, which is intended, or in fact, a present value analysis that is intended to compensate for the time value of money. And part of that compensation for the time value of money, Canada is acknowledging responsibility for part of that because Canada didn't engage in a process, and that probably led to delay in the First Nations receiving their award. So I just wanted to go now to why it's Canada's position that allocation between the crowns is covered by the Constitution, in particular Section 109. And it would be helpful to put 109 up on the screen, even though I know we went through it many times in evidence. So you're probably familiar with it, but let's put it up. And it's in the compendium. You'll see it in our compendium. Do you
Tab 9.
Oh, here we go. Thank you very much, Ms. Sang. It's up on the screen. Maybe you could try and increase the size so I can read it. Thank you. The Constitution says all lands, mines, minerals, and royalties belonging to the several provinces of Canada, Nova Scotia, and New Brunswick at the Union, and all sums then due or payable for such lands, mines, minerals, or royalties shall belong to the several provinces of Ontario, Quebec, Nova Scotia, and New Brunswick, in which the same are situate or arise, subject to any trusts existing in respect thereof, and to any interest other than that of the province in the same. This provision makes it clear that Ontario received the lands and minerals and royalties and sums then due and payable for them, subject to a trust or interest other than that of the province in the same, and that the First Nations interest in the proceeds in the resource revenues constitutes the kind of interest that's spoken of in Section 109. So what about Canada? Common sense and common law suggest that similarly, any lands or proceeds of lands that Canada received were also subject to a trust or interest in favor of the First Nations, in the sense that the First Nations have an interest in the proceeds because they are to fund their increased annuities. And we talked during the trial about Section 108 of the Constitution, for example, gives ordinance lands to Canada. As it happens, there were no ordinance lands in these sales of ordinance lands in these territories, and no other revenues of Canada, but certainly on a common law and common sense basis, Canada would be similarly liable for the interest of the First Nations. So this gets me into the common law of state succession. We have also called it in our pleadings, for example, the Commonwealth common law. First of all, I readily accept that Ontario has some criticisms, some valid criticisms, that the law of state succession usually deals with situations in international law and is really quite complex, and that the Irish Railways case from 1925, which is the one we rely on, is less than clear. But nevertheless, it does stand for the proposition that the assets and future liabilities connected with a particular function should be transferred at the same time. So I've included that case in the compendium, and happy to go to it, but I think if I just summarize for you, because you may remember this actually came up in stage 2 as well. This was a case where
Might even have been stage 1.
maybe both then. The British, so I don't know whether it's necessary for me to go through it again. You've got it in our written materials, and we rely on it, as well as what we has referred to as the Alberta Indians case, the Indian Association of Alberta case from 1982, which my friends have already taken you to. We've cited Lord Kerr at paragraph 314 of our factum. And I think, in fact, it's probably sufficient for you to have reference to those citations in paragraph 314 and 315 of our written submissions. If,
Sorry, did you give me something in the compendium on this case?
yes, the excerpts from Irish Railways are included in the compendium
At what page, at what tab?
at tab 5.
Thank you.
So I'm going to, sorry, my friends tell me it's at tab 2, and I'm going to our written submissions at paragraph 314 and 315. And I will read the relevant site. So at paragraph 315 of our written submissions, we cite from Viscount Cave, who was one of the lords in the House of Lords that determined the Irish Railways case. And just to give you some background, a reminder of the facts of this case, the British government had an agreement with a railway company operating in Ireland, whereby it took rail lines and rail ties, which are called sleepers, to lay elsewhere for the war effort, and agreed then to compensate the railway company after the war. When the Irish Free State came into existence, it received the rail lines and the sleepers, or the ties, on the land that had been taken from the plaintiff railway companies by the previous British government. In this case, the House of Lords held the Irish Free State responsible to compensate the railway company, as the British government had promised. It was the British government that promised compensation, but the Irish Free State that was held liable. And Viscount Cave explaining that since the Irish government received the railway lines to which the rails were transferred, it was responsible to compensate the railway company. And the quote that we have here, Viscount Cave explains it at the very end of the quote, when he talks about the railways having become under the control of Ireland. He says, it was natural that the assets and future liabilities connected with that function, the transportation function, should at the same time be transferred to the government of that state. So assets and liabilities are transferred in tandem. And this is made more clear when it's picked up later by Lord Kerr in the Alberta Indians case, which we cite at paragraph 314 of our submissions. This is the one that is also known as Indian Association of Alberta. My friends took you to it. It's a 1982 case. And Lord Kerr says very succinctly, after going through the Irish Railways case, he states the proposition as this, quote, the liabilities of the Crown in right of or under the laws of one of the Crown's territories can be satisfied only out of the revenues and by the authority of the legislature of that territory. The legal principle that underpins these cases is that the emanation of the Crown that receives the benefit of certain property is responsible for discharging the associated liabilities. And that principle is also what animated the arbitrators under section 142 of the Constitution in 1870 in allocating debts and liabilities of the old province of Canada between Ontario and Quebec. You may remember that we heard evidence about the award that was made by arbitrators Gray and McPherson alone, because the arbitrator Day for Quebec had resigned. You may remember the evidence was that there was a May 28, 1870 judgment that the two arbitrators, in which the two arbitrators had said, we should be following the local, what they called the local benefit principle, that the assets and liabilities, the liabilities should be split between Ontario and Quebec in proportion to how the assets were split between them. Justice Day resigned, and the final award that was made, I believe it was September 3rd, 1870, is the award that, without specifying that it was on the local benefit principle, nevertheless split liabilities essentially 5/9 to 4/9 between Ontario and Quebec. The point being that I'm trying to recall your honor's memory to that evidence that we heard, but the point being that the local benefit principle is what was applied there, which is the government that receives the asset should also be responsible for the liabilities that go with it. It's not an unusual proposition, Justice Hennessy. It flows from common law and common sense.
So the debt, how did they work out that ratio? Was it
Interestingly,
the land? Was it the size of the land or?
Interestingly, they didn't in their award, and we'll turn it up. They didn't actually go into detail about how they split it up, other than to say it shall be split by the proportion by which X amount of money to X amount of money, which works out to essentially 5/9, 4/9. And one of the points that was made in the evidence, Your Honor, was that the award isn't really clear about how the arbitrators came to that division, but their guidance award, their guiding award from May 28th, earlier that year, May 28th, 1870, expressed just arbitrators McPherson and Gray's opinion that it should follow how the assets are divided between the new provinces of Ontario and Quebec. And so depending on how you divide those assets, then theoretically liabilities that pertain to an asset that went to Ontario become the liabilities of Ontario, and likewise for Quebec. Of course, acknowledging that it's very difficult to split these assets. And, we talked about assets like, a canal or something that runs through both, and how difficult it would be to apportion liability. So, I readily accept that this wasn't a perfect split, but that May 28th, 1870 award speaks of the local benefit principle. And if you'd like, I can take you back to the evidence of Barbara Messamore and Gwyneth Jones on that. If you'd like, I'll get you those references.
If you have them at hand, yes, otherwise.
Well, they're in my written submissions. I don't actually have them at hand here.
They're in your
but-
written submissions.
Okay, they're in the written submissions. So, I think we can then turn to the historical background, and there's this historic debate was always between whether once it was accepted that increased annuities were due. And remember, the parties at the time, not including the First Nations, but the governments at the time, understood that the increases were capped at $4 per person. And I will show you in the record where you can see that that was the understanding of the Crown actors at the time. That was the understanding that they were operating under. So the historic debate as to who should be responsible for these increased annuities was always between whether the increased annuities were a debt of the province of Canada that existed at the Union and should then be assumed by the Dominion under Section 111 and then recouped from Ontario and Quebec under Section 112. That was one route to follow. And on the other side of the debate was this idea that no, the increased annuities were an interest of the First Nations in the proceeds of the ceded lands. And therefore, Ontario alone was liable to share the revenues or pay the increased annuities on the basis of Section 109. So the debate was always between, is it a Section 111, 112 situation, or is it a Section 109 situation? And Dr. Messamore characterized it this way. She said, is it either a Section 111, 112 debt existing at the union, or is it a Section 109 interest of the First Nations? So what I'd like to start doing, and I think we can start now and get through some of it, is actually looking at the Supreme Court of Canada decision in detail, the one that is highlighted, and I think you should have an electronic copy, and we will be putting it up on the screen. The reason I want to turn to it is, fortunately, back in the day, the Supreme Court reporter would include not just the actual decision of the judges, but a really helpful preamble to explain the dispute, which includes, in this case, not only the awards of the 1870 arbitrators and the third award of the 1895 arbitrators, but also the arguments of counsel. And so it's really helpful. So I want to go through this case in a fair bit of detail for a few reasons. One of which, of course, is my friends from Ontario argued that it is res judicata. So it's very important that you fully understand exactly what was covered in this case. And that's a reason to go through it in detail. But another reason is that it very succinctly summarizes the relevant history. It really hits all the highlights that you need to know in one spot. And the third reason is it addresses these very same legal issues that are before you now. You will see the same arguments being addressed in this decision that are being made before you. And so it will be helpful for you to see how the Supreme Court dealt with it. It is striking, actually, how relevant. I really want to impress upon you, among the thousands of papers you will need to read for this case, that this is a very important one. And so I'm going to go through it in detail. It is striking how relevant it is because the same arguments.
Top of the pile. As all Supreme Court of Canada cases do.
Well, Canada is not asking you to overturn this decision. We are asking that you consider it in light of the stage 1 interpretation of the treaty. And the obvious conclusion when you do that is that only the minority opinion is consistent with the stage 1 interpretation. And I don't think that's the same thing as saying overturn this decision. It's not, what I'm saying is pay close attention to what the Supreme Court judges had to say here. They did a very good analysis, but note that they were analyzing effectively a different treaty, a different interpretation of the treaty. So I don't think I'm actually asking you to overturn the case as much as I'm asking you to, take from it the propositions that apply, knowing what the stage 1 interpretation of the treaty is.
And will you be addressing the argument Ontario makes based on the evidence from Ms. Jones that Canada always knew, that certain actors of Canada, from Canada, always knew that the treaty, that the augmentation obligation could be more than $4?
I can address that now.
If you're addressing it,
Yep.
I'll let you do it in your time.
Certain actors from Canada always knew that it could be go beyond $4. I think it's even noted in here, anything beyond $4 would be a matter of grace. So that was well acknowledged. And you will also see in this decision that, of course, Canada's position was that the proper interpretation of the treaty was that it gave the First Nations an interest in the proceeds of the ceded lands. So that Canada acknowledges, and that is dealt with by the judges, but there is also no doubt that the way all of the parties were reading it at the time was as though the $4 applied to the entire annuity, to the annuity payable to the tribes, is the way that they put it. The annuity payable to the tribes was to be calculated on the basis of $4 per person, subject to Her Majesty's graciousness. So there's no doubt there is this acknowledgement that it could have been more than $4, but that would be subject to Her Majesty's graciousness, is the way they understood it, that was a matter of discretion.
Not an obligation.
What makes that different today is we now understand the treaty to be, there is no discretion. There's no discretion, and there's no cap on the collective annuity due. That's the finding of this court and the Court of Appeal. That understanding was not in the minds of the Crown actors in the day. Even if they understood that $4 wasn't an absolute cap, because they understood there was the possibility for the exercise of Her Majesty's graciousness, they understood it as one annuity. And they understood that the graciousness applied to that annuity. Now we understand it as two different annuities, a collective amount that is not at all subject to any cap whatsoever. That's a different understanding than any of the parties had at the time, except the First Nations.
I thought you did not say it was two annuities, but one part of another. That there was a single annuity.
No, we accept this court's determination that there are two annuities. There is well, I guess it depends on how you look at it, I understand. That there are two components to the annuity. There's a collective component that has no cap whatsoever, and then there is a distributive component that is subject to discretion, in the sense that it's, first of all, subject to consultation with the First Nations now that we understand the judgment. And that's what the $4 refers to. I'm sorry if I understand I was unclear about that point. But certainly at the time, I submit to you, and I'll show you the language that I'm relying on to suggest that the government and Crown actors at the time and the judges in the Supreme Court did not understand that the $4, that last bit of the treaty about $4, they did not understand that only applied to the distributive amount. They understood that $4 was a cap subject to graciousness of the collective amount. So we do have time, I think, to start with, there's different elements of this report that I want to go through. The first is the preamble, which sets out the history. Then we will look at the statutory arbitrators in 1890.
Is this in the compendium?
It is. It's at, I think my friend said it was tab 2, right? Or tab 5.
Thank you.
No, it's,
So tab 7 is.
yeah, it's tab 7 of the compendium. I should say too, if you're looking for it in our authorities, it's actually listed under T for the province of Ontario. So if you're having trouble finding it, it's under T, the province of Ontario. But as I said, to make things easier during these submissions, I suggest that you look at the highlighted version that we've sent to you by electronically this morning, Justice Hennessy. It's the same report, same reported case, but highlighted. And so you don't have that in paper?
I'll just make a note of that.
Okay. So just to start then, and here I'm going to ask Ms. Sang to put up on the screen, and I hope you can see your screen more clearly than we can see the screens in the gallery.
Oh, indeed I can.
Okay, good. So where I'm going to start is page 439, because here we're dealing with the preamble in the Supreme Court report that it describes the history. And I just think it's helpful to go and refresh our memories about the section 142 arbitrators in 1870. These were the ones I had mentioned before who were determining how to split the debts of the province of Canada as between Ontario and Quebec. And so reproduced at the beginning of page 439 and highlighted on the screen there is the section of section 142 of the Constitution that says that it shall be the issue of division of debts shall be sent to the arbitrament of 3 arbitrators. And the next highlighted passage on that page indicates that 2 of those arbitrators, Gray and McPherson, gave their award. And the relevant part then is on page 440. And I think I like to go through this and we may be able to end the day there. That in clause 13 of their award, and this is the award dated the 3rd of September, 1870. We know that from page 439, the highlighted portion said it was, as I mentioned earlier, the 3rd of September, 1870. The 13th clause says that all the lands in either of the said provinces of Ontario and Quebec respectively, surrendered by the Indians in consideration of annuities to them granted, which said annuities are included in the debt of the late province of Canada, shall be the absolute property of the province in which the said lands are respectively situate, free from any further claim upon or charge to the said province in which they are so situate by the other of the said provinces. That's the key phrase, by the other of the said provinces. And we'll come back to this because you will see, unfortunately, the Chief Justice forgets this phrase when he addresses it later. And my friends from Ontario have made the same mistake in their written submissions. They forget that when the arbitrators found that Ontario took the land free from any further claim upon it or charge to it, that was only charges or claims by the other provinces, not by the First Nations. I think actually we have just a few extra minutes to just then set the stage for the next arbitration award. So that was in 1870.
Set the stage, Monday.
Monday, all right,
I think that would be better.
thank you.
Okay. I hope you agree. We'll break now for the day and for the week. Mr. Bass is on his feet.
I
Oh.
just wish to make a couple comments off the record.
All right, so just we'll break for today. We will resume again Monday at 10. Is that fine? And then we'll go off the record.
Thank you.
All right, got that? Okay, go ahead.